this is Mr. Valentine, whose matters, I believe, are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe my office had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed, and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
Okay. All right. Well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So,
buckle up, guys. We're diving into an explosive courtroom moment and warns about the perils of DIY defense, with a vivid pilot analogy and stern reminders about self-representation risks. The prosecution leaps in, laying out 2 DUI counts from 2021 and 2024 and a history of failing to appear, all under looming $115,000 warrants. In this opener, the judge sets high stakes, foreshadowing procedural battles ahead and underscoring that courtroom rules spare no one.
Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up, because I was confused about the dates. The clerk told me the wrong date. I showed up, I gave the clerk a letter, I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in, or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as, what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce it. If not, I do not wish to contract with any members of this court. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi.
Well, Mr. Valentine, I'm going to hold you on 15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately. And then.
All right, guys. Tension spikes as Valentine contests bail, blaming clerical chaos for missing court dates and unleashing sovereign citizen claims, rejecting personhood and licensure laws. Undeterred, the judge sets $15,000 cash or surety bail on each DUI, orders scram monitoring, sobriety checks, valid license and insurance, and demands pretrial services within 48 hours. This exchange highlights the friction between his defiance and rigid procedural controls, reaffirming that courtroom protocols won't bend to fringe legal theories. This clash cements that pro-SE zeal doesn't eclipse the court's authority or its safeguard measures.
You have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law-abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns, and don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Or what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do it.
I am not pro se. I'm a seri juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that
No,
oath
it's
today,
just
ma'am?
free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona, that I live in the likeness of another?
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to the facts, ma'am.
You can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
One attorney.
So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do post bond, you have an obligation to get into pretrial services within 48 hours.
All right, guys. Part 3 unfolds with Valentine doubling down on jurisdictional challenges, labeling this a NI Prius court and demanding rule and implementation. His invocation of constitutional oaths and insistence on sui juris Identity creates an almost surreal showdown. The judge refuses to engage in semantic tangles, reaffirms jurisdiction, and reminds Valentine he can request counsel anytime. The hearing wraps with a date set for September 20th, hinting at more clashes ahead. This clash underscores how fringe arguments collide with strictly enforced timelines and courtroom decorum, setting a dramatic tone for the next hearing.
And comply with them for sobriety monitoring, and that substance use monitoring program will pay for the Scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post stamps.
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm a sound
I'm
mind
not
body.
denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel and talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. I'm doing that. All right, so we're done today, and those orders will be given to you in the jail.
What case are you here for? Okay. And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah, hold
I'd
on,
like
hold on. I'll let you know when I need to hear from you.
okay.
So Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation. I have
Okay,
advised.
well, okay,
He wants
I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you, that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with two cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself.
Buckle up, guys. We rejoin on September 20th as Valentine returns with family in the gallery, still declaiming pro-SE intentions. The judge issues a stern warning. Self-representation will be held to attorney-level standards, and mistakes won't be excused. Valentine's choice to fly solo sparks a cautionary lecture on the perils of serving as one's own lawyer, especially with up to 2 years of potential jail time looming. He stresses that even trained lawyers avoid representing themselves, highlighting a well-known maxim that self-representation is folly.
Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
Are you attempting to intimidate me under the color of law?
Do you have any questions for me?
That was
Other
the
than that,
question.
no, I'm not attempting. I'm trying to make it very clear to you that I think it's a big mistake.
I'm ready to proceed.
Okay. All right.
So First of all, I would like to address we the people, and I would ask that they would all stand for a moment.
No,
People are
just,
special appearance.
no, we're not doing anything like that. We're here on a pretrial. You have a confirmation hearing set for the 18th of October. Mr. Valentine, you have anything to say about that status? Otherwise, we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you. It was why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing and have consideration of those. Hi, folks, I don't want to hear any comments. None. So 18th of October is when he's due back.
And that's set for trial confirmation, Your Honor?
It's set for trial confirmation.
Thank you, Your Honor.
And Amy, if you'll make a note to...
Picks up with Valentine reasserting his sui juris stance, rejecting person status and formal titles. The court clarifies the difference between special appearance and pro se, then confirms a status hearing on October 18th and trial on October 18th to 19th. Amid his protestations, the judge draws a firm line. Process trumps personal narrative, and procedural cadence will govern the case timeline, regardless of Valentine's identity declarations. That scheduling anchor underscores the court's commitment to timeline integrity in the face of persistent challenges.
We need to get you unmuted.
Yes, ma'am.
All right. So there are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not?
No.
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay. I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court. A motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court, and I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony, to my house. I'm not sure what that was. The motion was never served to me, and the docket was never served to me either. It was mailed to my home. I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay. Well, this is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
It's
Mr.
the state's
Weston?
understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether the court should grant funds for Mr. Valentine to hire an investigator.
That were filed.
There was a motion filed. I can look it up real quick, Your Honor.
Since the last hearing is what I was looking at. So there was.
Yeah, I objected to his denial of those motions as well, because I already submitted an affidavit of prejudice and he disqualified himself. So he shouldn't have been making any judgments on the case after that point. He also said himself that today was going to be a special motion docket where my motions were going to be heard today.
So what I reviewed is what was filed after the 18th. And that was October 21st. I have a request to release you and your request, I'll go back, let me get back to your court to dismiss these charges, motion to release you. And that's what I reviewed. So is there something else?
Buckle up, guys. Valentine gears up to argue a series of motions: dismissal, judicial notices, motion to strike, only to find the prosecutor insists only funding for an investigator was on the docket. He claims he never got to present his October 18th motions. The judge reviews filings, noting new motions filed on October 21st, and signals he will deliberate on which pleadings were properly noticed, staging the next procedural skirmish. This exchange showcases the fine print warfare over calendar control and notice requirements in pro-SE litigation, foreshadowing another round of legal jockeying.
Pending that I was not aware of after the 18th.
On this October 18th, there's one that says in Laserfish motion to request discovery, parentheses 020, parentheses. In that one, that's based on the state's notes. It shows that that was the only motion that was going to be argued today.
All right, Mr. Valentine, it looks like I need to go back and kind of review real quick those issues. I thought they were all heard on the 18th. And either you can just sit right there while I read everything here, or which probably is the best thing to do. So let me just review all that you've filed here again. Then I'll turn right back to you. So just hang in there. So, just before I get to everything, Mr. Valentine, motion request, I guess you titled it to request all of the discovery in this case, but you say that it seems to me, maybe I'm misreading, one, that Michael Valentine had an attorney in the early stages of the hearings. Is that just a fact, or are you asking the court to appoint counsel?
I'm stating a fact that at the beginning of these proceedings, I was working with an attorney.
And then they never gave you the discovery. Okay. All right.
Yes.
All right. All right. Get it.
That's the state's understanding as well, Your Honor.
All right. I've had some time here to review and review what's been filed in the court file from the 18th of October on forward. As to your motions from the 18th on forward, and the docket and your pleading. So as to discovery, let me direct first to Mr. Weston on behalf of the state. Has all discovery been provided to Mr. Valentine?
Correct, Your Honor. So on October 18th, 2024, Judge Buckley ordered that the state provide Mr. Valentine discovery. 5 days later, DPA Thompson himself drove to the jail and delivered all discovery material to Mr. Valentine, which included the citation, police reports, an offer sheet from our office, thumb drives of dash cams, and then the request forms for those dash cams as well.
He could view those, a request form for the dash cams. What does that mean?
That when there's a dash cam involved, such as here, our office generally has to send out a request for that dash cam, and that form is just a request asking Washington State Patrol to disclose their dash cams to us.
Okay, but you provided a thumb drive that had those dash cams.
Correct, Your Honor. Thumb drive of the dash cams.
And all this information is what the state intends to use in trial against Mr. Valentine.
Correct, Your Honor. Based on the subpoenas that I looked at recently that were sent out for trial, the trooper that's testifying is one of the troopers that is testifying. His dash cam would be on this drive. The police report of that trooper would have been provided in this discovery packet as well. All the information that we would be using at trial was in this discovery packet that was provided to Mr. Valentine on December 23rd.
All right, guys. Here the prosecutor confirms all discovery. Police reports, dashcam footage on thumb drives, citations, was delivered to Valentine's former counsel and later handed over to him in jail. Witness lists, including troopers and Draeger technicians, were also shared. Valentine challenges the timing and redactions, accusing counsel of ineffectiveness, but the court focuses on completeness. laying groundwork for motions to suppress and evidentiary battles. By spotlighting chain of custody details and disclosure protocols, this stretch lays out the foundation for upcoming suppression arguments, illustrating how discovery deadlines and delivery can become a battlefield in its own right.
Was it provided before this at any point?
The state is unaware on whether it was or not. The states had the belief that defense counsel, who was previously representing Mr. Valentine up to a certain point, would disclose such materials to him when the court found that when the court allowed Mr. Valentine to proceed pro se. But this state doesn't know why it wasn't provided to him from the prior defense counsel. But upon realizing that Mr. Valentine did not have the discovery packet, the state did provide such material at that time.
And on the witnesses that you're expecting to call to testify, the substance of their information is included in that discovery?
I would believe so, Your Honor. Based on the subpoena that was sent out, one of the witnesses are Trooper Benjamin Crabtree, for one of a dragger technician, and because there was one of the charges is driving while license suspended, there is a DOL representative that it will be a witness in the trial as well.
It looks like a witness list was provided while Mr. Gasling was Mr. Valentine's attorney back in the beginning of the year, at least March, I believe it was. So then, Mr. Valentine, as to that discovery, you thinking you're missing something or you should have something else in discovery?
No, ma'am, I didn't receive the discovery in a timely manner. Counsel was ineffective in the discovery footage or the reports with me. I asked on multiple occasions to obtain the video so that I could build a proper defense. And they told me on multiple occasions that it had to be approved by the prosecutor and redacted, which never happened. I waited and waited, never happened. And after counsel's ineffectiveness, this is where I made the choice to proceed to the jurors because I had my own best interest in mind. And it seems that the public defenders that were appointed to me were not assisting me effectively. And this was recreating a manifest injustice. So now I have received it a few days before we're supposed to be going to trial. I have reviewed the footage, and there is fraudulent and misleading statements made by the trooper that I have already submitted a motion to suppress that evidence that I'm sure the court will be getting shortly.
So we're a couple weeks before trial, or before confirmation. We've got trial scheduled the 18th, so we're 3 weeks out. All right.
Yeah, I would ask the court that either the prosecutor or counsel be sanctioned or some remedy be met for the violation of discovery.
Sanction anyone for a violation of discovery. So I'm not going to do that. And now you're also, I don't know if this was dealt with, but throughout your pleadings, you're concerned about this district court having jurisdiction over you. Is that still at issue, sir?
Yes, there was some service issues, as I mentioned before, which for some reason it keeps getting ignored. The state served my address knowing well that I was in custody. They didn't serve me the court docket for the last hearing. And that lack of service creates a lack of jurisdiction for the court.
I disagree. Those are different issues. Go ahead, though. Maybe you've got something else there. What?
Buckle up, guys. Valentine amps up his complaints, demanding sanctions for alleged discovery violations and courtroom misconduct. He vows to file a suppression motion over perceived trooper misstatements. The judge, unfazed, finds no sanctionable conduct and reiterates the discovery is now complete. Valentine's insistence on sovereignty, ADA pronoun usage, and fee schedules meets procedural firmness, underscoring that theatrical filings won't derail the court's methodical advance to trial. This segment highlights the clash between procedural rigor and irreverent courtroom theater, raising stakes before trial confirmation.
Oh, I was just going to say there's also been a number of courtroom violations taking place, which is why the the last judge ended up recusing himself. But beyond counsel being ineffective in mounting any defense, they convinced me to give up constitutional rights instead of enforcing any constitutional rights. They lacked to challenge anything that the state was doing. They didn't challenge or attempt to suppress the evidence. They didn't even share the discovery information with me upon my request. And the court also was violating General Rule 43, my personal pronouns, continuing to try to say I'm pro se instead of sui juris, not changing, acknowledging my name or acknowledging my status as an American national. I also submitted a letter from the Washington State Attorney General's office where they're acknowledging my status as an American national. They're acknowledging my fee schedule, but for some reason this court hasn't been acknowledging my pronouns at all.
Help me understand what you would prefer.
I would prefer to be identified as sui juris, not pro se. I prefer to be identified as Michael Valentine, grammatically correct, not in all capitalizations. I am not a legal entity. I am not a corporation. I am not a trust. I am a living man, not a male. Living man. And that's how I want to be identified, ma'am.
So if I say Mr. Valentine, that's not what you want.
I would like to be preferred as American National Valentine.
All right, guys. Once again, Valentine rehashes jurisdictional challenges, serving defective process, Rule 43 infractions, sovereign citizen rhetoric, while the judge methodically dismantles each claim. He reaffirms that alleged procedural missteps don't strip the court of authority over DUI offenses in Thurston County. Valentine's litany of fee schedules and pronoun demands is met with patient rebuke, reinforcing that technicalities can't override substantive jurisdiction. This back and forth crystallizes the court's unwavering grasp on jurisdictional fundamentals, setting a clear boundary between theory and enforceable law.
The jurisdiction, whether Thurston County District Court has jurisdiction over you at this stage, what it is an allegation of criminal behavior alleged to have been occurred here in Thurston County, State Route 510 here in Thurston County. And so that, and it's driving under the influence, it's a gross misdemeanor. So the district court does have jurisdiction over those things and over you, whether you agree with the court or not. I find that today. And then discovery sounds like it's been provided. We're 3 weeks out from trial.
We're 3 weeks out. The trial was like next week.
Well, next week, the 8th is the day, it's called confirmation. It's when everyone determines if they're ready for trial or if we should have trial on the 18th and 19th. So the 18th and 19th is trial. So we're 3 weeks out. So I'm finding that thus far that discovery has been provided by the state to you.
But it wasn't in a timely manner. It wasn't by the omnius hearing, which is the prosecutor's obligation.
Well, and it was provided to previous counsel who was with Thurston County Public Defense. I don't have, there isn't any counsel here today now because fairly you've decided to go sui generis, as you say. So
and that's why my motion for discovery asked for an investigator, because someone needs to investigate all these rules being broken by counsel, prosecutors, and various government individuals.
Finding those rules being broken, it's kind of a broad and encompassing idea. I'm trying to narrow this in. See, discovery has been had.
To share the discovery with me and to contact me and to help build a case. If I'm requesting a discovery, wouldn't either the prosecutor or counsel have an obligation to provide that discovery?
And I see that they have now, the prosecutor has. Now as to...
But they didn't previously is my point.
Right, and they have now. And I don't find at this stage a reason to sanction anybody or to term anybody for that. There's 3 weeks out to trial. It's sufficient time. So You also have a motion for release. That was also, let's see, and a motion to dismiss.
And the motion to release and dismiss were both heard on the 18th. And I can provide some
So
underlying facts.
Mr. Valentine, there's something on the 18th, but then you refiled information that I reviewed on the 21st, also asking the court to consider release and a motion to dismiss the action against you. And is there something different than what you argued on the 18th that you filed on the 21st?
I didn't get to argue anything on the 18th. The judge read and made his own decision. I didn't argue anything. He told me on the record that I would get a chance today to argue my motions, and I presented certified mail receipts of the time that those were filed to the court as an exhibit, and he didn't allow me to speak or acknowledge any of those notices or motions, which is denying me access to court and obstructing my right to be heard, which is a constitutional right, a violation of due process.
Buckle up, guys. The final stretch confirms the schedule. A confirmation check-in on October 8th and trial on October 18th to 19th. Valentine notes new filings from October 21st, prompting the judge to review and close the hearing. Orders will be delivered in jail, while the court calendar remains firmly on track. The episode closes with procedural order, as theater yields to timetables. If you enjoyed this breakdown, hit that like button, subscribe for more in-depth analyses, and we'll see you in the next video.